Good afternoon, everyone. Today, my group, Surbhi Singh, Girish K, Satalla Rao, Aditya S, and myself, Preeti Kumari, we are going to present on the topic Remedies for Breach of Contract under Indian Law. So, there are three types of remedies for breach. First, damages. Second, specific performance. And third, injunction. Now I am going to explain about overview of Indian contract law. So Indian contract law governs the formation, execution and enforcement of contracts in India. It ensures that agreements made between parties are legally binding and enforceable. The core principles include offer, acceptance, consideration and mutual consent. This law applies to both commercial and personal contracts and aims to protect the interest of all parties involved. Now I am going to tell about the importance of enforcing contract. So enforcing contracts is essential for first, maintaining trust, second, promoting economic growth, and third, ensuring accountability. And next I am going to explain about legal foundation. So the Indian Contract Act 1872 is the primary legislation governing contract in India. It defines what constitutes a valid contract, the right and duties of the parties, remedies available in the case of breach. It applies to all type of contract except those specifically excluded.
Hello guys, myself Rahul Satarla. The point I am speaking is damages. Damages refer to a monetary compensation awarded by a court to a party who has suffered loss or injury due to the breach of contract by another party. There are four types of damages. First one is compensatory damage, which is direct loss. These are awarded to compensate the injury party for the actual loss. It may be directly arising from the breach. For example, if a supplier fails to deliver goods and the buyer has to buy the same goods at the higher price, the difference in price is direct loss. And the second one is consequential damage, which is indirect loss. These damages are losses that do not flow directly from the breach but occur as consequences of the breach. They must have been reasonably forcible by both parties at the time of the contract. For example, if the failure to the delivery machinery results in product loss, the profit loss is consequential. And third one is nominal damages, which is non-actual loss. When there is a breach of contract but the party suffers not real loss, nominal damages are awarded. It is like a token amount, like 1 rupee. Acknowledging that a legal right was violated even though a subsequent harm was caused. And fourth one is liquidated and unliquidated damages. Liquidated damages. These are pre-agreed sums written in the contract, payable in case of the breach. They are predictable and certain. For example, a contract states that a delay will be lead to 10,000 rupees day as a damage. Unliquidable damage. These are non-pre-decided. The court accesses and determines the compensation based on the actual loss suffered. There is a relevant section for that. Section 73 of the Indian Contract Act 1872. It deals with compensation of loss or damage caused by a breach of contract. According to this section, when a contract is broken, the injured party is entitled to receive compensation for losses that naturally arose from the breach or losses that were in the compensable of both parties when the contract was made. However, remote or indirect loss is non-computable under this section.
Hello everyone, today I will be talking about specific performance. Specific performance is a legal remedy in contract law wherein the court orders the party who has breached the contract to fulfill their original obligation as agreed, rather than simply compensating the aggrieved party with monetary damages. It is an equitable remedy, meaning it is granted as the discretion of the court based on the fairness and justice. In simple terms, if someone does not honor a contract, instead of just awarding money for the breach, the court can order them to actually do what they promised in the contract. When applicable, when monetary compensation is not sufficient to cover the loss, and when the contract involves unique subject matter such as real asset, artwork, or rare goods. Legal basis. The remedy of a specific performance in India is primarily governed by the Specific Relief Act 1963. This act defines the situation in which a specific performance can be ordered, the defense available to the breaching party, the condition under which the remedy can be refused. Under the Act, a specific performance is considered not just as a right, but as a dictionary remedy. This means that if all legal conditions are satisfied, the court may still refuse to grant if it is deemed too unfair or impractical. Limitation: contract for personal service. Specific performance cannot be ordered for contract that require personal service, such as employment contract. Court will not force a person to work for someone or perform personal tasks, as this could violate personal freedom and dignity. Contract requiring continuous supervision. If the performance of the contract would require constant monitoring by the court, it is generally not enforceable through specific performance. Court do not have the resources or authority to micromanage ongoing contractual relationship. Unfair or impossible performance. If carrying out the contract would cause undue hardship, be impossible, or involve unfair conduct by the party requesting specific performance, court will not grant this remedy.
Hi, I'm Aditya. An injunction is a court order that direct a party or either perform or to abstain a specific order or abstaining the doing from such an act. So it's primarily to prevent a harm or enforce a right. It's governed by the Specific Rule Act of 38 of 1963. So when it comes to types of prohibitory injunction means like it's a prevent harm or infringement of rights governed by the Section 30 of the specific act. It's like a abstained or doing from any such specific act that ensuring the legal right of the aggrieved parties. It's also called as a restrictive injunction. There are some of the conditions that must be fulfilled in order to get a conjunction. Some of those are existence of the legal right. When existence of legal right is threatened by the action of the defendant. Second, the threat of irreparable harm. That is such of a nature that it cannot be adequately compensated by the damage when it is continuous and recurring monetary compensation is not suffice. Third is a lack of adequacy of remedy. If there is no adequacy available to the applicant to the normal legal channels. Fourth is the balance of the convenience between the parties. There should be always a balance between the convenience between the parties. Fourth is the conduct of parties. Whenever they will be approaching the court, they must come clean and approach the court. And there is some division of the restrictive conjunction. There are temporary as well as the perpetual injunction. Temporary is for the specific period until the case is held in the court. And the perpetual, it's a outcome of the case. There are some of the practical implications. There are the property disputes, IP rights, contractual obligation, environment protection. These takes a very prolonged time to solve the case. So these are the temporary. By the time of coming perpetual injunction, it takes a lot of time. And fourth one is the mandatory injunction. Mandatory injunction is an official order given by the court telling that someone that they must do something to restore the status quo. It's also second is to compel them to perform the required. It also requires the affirmative steps. Mean like in a prohibitory is a kind of a direct court give a direct decrease. It's not unlike in the mandatory. There should be an affirmative step. Then only some mandatory injunction is possible. When it comes to the practical implication, the time taken by the litigation is like whenever you going to seeking a injection, it involves a urgent hearing, but litigation can still become lengthy and expensive. If contested, it becomes big issues. Temporary injection is given for the specified period of time that require full trial on the merit of the court. There are some of the enforcement issues when there is a non-complication with the injunction can lead to the court proceedings which may involve fines and imprisonments. Practical enforcement, removal of structures, stopping of ongoing. These are the practical enforcement of removal structures, as we can say as a structure stopping or ongoing activity, removal of the existing buildings. Role of the ADRs means like they are the arbitrage mediation. They will help the party to solve the dispute without resorting to court orders instead to save the time and cost. Court held the exclusive asset. Even though the court held, they can act as an arbitrator to solve the issue without getting into the court. So they can act as a supplement, but not replace the judicial interventions. When it comes to the importance of the ADRs, if the contract is well drafted, they can be specified, including right to send the injunction. Good drafting is also reduce the likelihood of the disputes. Then the clear clause means like when they have clearly drafted well, because all those hearings will be at the side of the defendant who are seeking just the injunction.
Hello everyone, myself Girish. I am here to conclude the remedies of breach of contract under the Indian legal system. The presentation effectively concludes by summarizing the core principles regarding the remedies of breach of contract under Indian law. It underscores that Indian legal system, primarily through the Indian Contract Act of 1872, offers a framework to address the situations where contractual obligations are not yet met. When a breach occurs, the law provides to protect the aggrieved party and restores fairness. Summary of remedies. The conclusion accurately points out the availability of various remedies, including damages, specific performances, and injunctions. These remedies serve distinct purposes and are applied based on the specific of the contractual breach. It is important that to emphasize these remedies aren't interchangeable. Damages provide monetary compensations, specific performance compels the breaching party to fulfill their contractual duties, and injunctions are court of orders that direct certain actions or prohibit others. Importance of choosing right remedy. The presentation highlights a crucial aspect of selection most appropriate remedy. The nature of the contract is a key determinant. For instance, a contract of a sale of an art of unique work might necessitate specific performances, while a contract of goods might be adequate to address through damages. The type of breach also influences the choice. A minor delay might warrant only damages, while a complete failure to perform might justify the specific performances or an injunctions. The extent of loss or harm is another critical factor. If the loss is necessarily quantifiable, the monetary terms damages are likely suitable. However, if the harm is irrepressible or injunction might be necessary. Role of legal advice. Finally, the conclusion stresses the importance of seeking expert of legal guidance. Contractual law can be complex, and navigating legal procedures requires expertise. Legal counsel can also provide invaluable assistance in understanding one's rights, assessing available remedies, and pursuing most effective legal strategy. This can significantly impact the outcome of an contractual dispute.